We're also joined by an advocate, that is Namit Saxena, on this broadcast. Namit Saxena, how would you really read into this entire stay coming in from the Supreme Court himself, and reading out from what exactly happened? That is SG Tushar Mehta, who had appeared for the centre, tells the Supreme Court that as far as the pending sedition cases are concerned, the gravity of each case is still unknown, but maybe there is a terror angle, a money laundering angle that will ultimately depend from case to case. But for now, it seems that more cases against sedition will not be applicable till July.
This is a historic, point of view. The middle ground which the centre and the judiciary have taken, this is a historic point, because this is, this is a colonial law. So by this, an impression or a suggestion which goes out is that even if there are colonial laws, then also, the Supreme Court thinks that they can be put in abeyance, although they have been in practice throughout. Then also it can be done that the government suggests so. So this is historic in this sense. Now the other angle to this is what Mr. Mehta suggested, that there are other terror angles or money laundering angles. See, what the Supreme Court has done is they have not put a blanket stay on all trials. They have rather said that, the proceedings under other sections of law would continue. So where there is a case of 124A coupled with other sections, for example, waging war, etc., or under POTA or whatever provisions of law, 153A, for example. So under those sections, the investigation and trial can carry on. There is no stay on them. But only Core 124A, there will be no investigations, there will be no trial, and there will be no coercive steps. So this is historical in both senses. One, a middle ground adoption, that approach of, the via media approach. And second, that, that keeping an abeyance of a colonial law, even while there can be other angles attached to it of money laundering or terror, or, other angles.
Mr. Saxena, on the point of view of the centre, because they were completely not in the favour of doing away with the law. Of course, we were hearing from the other side, Mr. Sibbal, who was representing the other petitioners, saying that there is no point of view and no point rather, all right, to have this law in consideration. Requesting you, Mr. Saxena, to stay on with us. Mr. K. Rahman Khan is with us on the broadcast. Sir, what is your point of view? Because the centre was not ready to completely do away with the sedition law. However, it is now being kept in abeyance in the clear directions given by the Supreme Court, sir.
Now, the sedition law is a draconian law as far as and it is being misused by the governments for a simple expression of freedom of thought or expression. They are charging sedition law, and this law requires a review, and it is a welcome decision of the Supreme Court.
And Mr. Rahman Khan, another quick question to you. Now that the sedition law has been stayed till July, how will the states really, in a way, interpret this order? What can be done in case of hate speeches or anti-national statements being made?
No, the anti-national, there is already there are laws. Sedition law is a serious listen, because for any anti-national, any other speeches, hate speeches made, we have sufficient provisions in the criminal procedure, which is equally punitive, and that will already lot of legal opinion has come that our criminal law itself, if it is properly implemented, it's sufficient to deal with such cases.
Mr. Rahman Khan, sir, thank you very much for your point of view. Mr. Saxena, if I can come back to you on that. Of course, we are listening to the point of view of other top leaders and politicians as well. But we are looking at a law that has been in place for several decades, pre-independent colonial era law. So it is not that any government who was there at the centre has not used it or misused it. Every government we have seen that in power has used the sedition law one way or the other. But as it is also being pointed out that there are other several laws and sections that are put in place equally tough when it comes to every angle that is also being looked into. What do you propose at the time when other laws can also be implemented or imposed and never the use of sedition law can be used or implemented?
There is a difference between sedition law and, for example, hate speeches. Sedition is causing disaffection towards the government, and it should lead to violence. Hate speech can be general towards any community at large as such as well. So when you look at the IPC broadly covers under 153A or 295A or 505A, that covers what hate speech or, if you target any particular community, there are sections that cover that. Now 124A, the sedition, and this was initially, if you see the ruling establishment under the British Empire, this 124A was worded not sedition as such. This was disaffection towards the government. So it is only qua the government that the primary argument of Mr. Sibal was this, that that the Kedarnath Singh judgment of 1962 that equates state and the government. Government is the ruling establishment, the state is the entity as such. So that is the error which Kedarnath Singh has committed. But this is a very welcome decision. As an interim provision, this is a very welcome decision of the Supreme Court, where they have said that, that we're keeping it in abeyance for the time being. So this gives a very broader perspective of other colonial laws as well, whether they are necessary in current India, in the democratic India also or also not. But when you talk about the misuse of this law, the misuse also has been rampant. This is what the Attorney General also suggested. For example, the Rana's case, which you pointed out just now, it is an outright abuse of 124A. So to control this, and also we have to keep in mind that, when the Congress government in 2008, they brought in the NIA Act, the National Investigating Agency Act. So this entire schedule of offences against the state can be directly investigated by the NIA. So it also has to be, looked into that what is the investigating agency which can investigate 124A or so or not. So therefore, this is a very welcome decision that you have stopped all the investigations also under 124A.
Right. Stay with us, Namit, and Ashwini Dubey also joins us on this broadcast. Ashwini, how would you really respond to this entire... In fact, this is historic in a way that till July now we are expecting the sedition law to be stayed. And the court has mentioned that all cases that come under the purview of sedition, they can now apply for bail and no new cases can be registered.